English legal shorthand 100 words per minute. Ready? In the present case, the petitioner has raised serious allegations against the inquiry officer himself. He has also made allegations against the union members. There is therefore every possibility of his facing stiff resistance in the proceedings. The petitioner has also alleged various unfair practices against the respondent. He has, for instance, alleged that the entire action is mala fide. He has alleged that this was the culmination of previous unfair treatment meted out to him by the respondent. He has alleged that he was threatened and abused by his superiors. Whether the same are true or not is another matter altogether. That is not relevant at this stage. Establishing these facts cannot possibly be simple for the petitioner without the assistance of a lawyer, especially when he is met with opposition from a legally trained person and where there is a serious allegation made by him against the inquiry officer and the union members. In the circumstances, the impugned order is set aside. The petitioner shall be entitled to appear through a lawyer for defending himself in the inquiry proceedings. The writ petition accordingly stands disposed of, but with no order as to cost. He would submit that the right to defend oneself in legal proceedings is a fundamental right, and the expression leave of the court should be perceived in a liberal manner to advance fairness and equality, and a straitjacket formula cannot be applicable to all cases. He would submit that the principle of audi alterum partem mandates that every person be afforded a fair opportunity to be heard and to be represented by the person of his choice, particularly where complex procedural issues or serious consequences are involved. I have heard Mr. More, learned advocate for applicant, and Mr. Patak, learned advocate appointed to assist the court, and with their able assistance perused the entire record of the case. Submissions made by both the learned advocate at the bar have received due consideration of the court. At the outset, it is seen that the controversy revolves around the interpretation of section 36(3) and 36(4) of the ID Act. The question which arises for determination is whether a small-scale employer, such as the present applicant before me, can be represented by an advocate in proceedings before the labor court, particularly when such representation is sought to ensure effective participation and fair adjudication, since the applicant